The Supreme Court just ruled against Hawaii in a major Second Amendment case, and the important part is not as simple as the court said businesses have to allow guns. That is not what happened. Private businesses can still say no guns. A grocery store can still post a sign. A coffee shop can still tell customers not to bring firearms inside. A property owner still has the right to exclude people. But the question in Wolford v. Lopez was different. The question was, what is the default rule? Hawaii passed a law saying that if private property is open to the public, a licensed concealed carry holder cannot bring a handgun onto that property unless the owner gives express permission. So if you walk into a gas station, grocery store, restaurant, or coffee shop, the default rule under Hawaii's law was basically this: no guns unless the business says yes. In legal circles, they call this the vampire rule, because just like a vampire, a licensed gun owner couldn't cross the threshold of a private business unless they were explicitly invited inside. The Supreme Court said that goes too far. The majority ruled that Hawaii violated the Second and 14th Amendments by making publicly accessible private property gun-free by default. And that is the real story. This case is about defaults, because defaults are power. Most people do not think about default rules because they are invisible, but they decide what happens when nobody says anything. Does silence mean permission, or does silence mean prohibition? Hawaii tried to make silence mean no guns. The Supreme Court said silence cannot work that way when the person carrying has already satisfied the state's requirements for a concealed carry permit. Justice Alito, writing for the majority, argued that Hawaii was basically trying to get around the court's earlier Bruen decision. Before Bruen, Hawaii made it extremely difficult for ordinary people to get carry permits. Then Bruen said the Second Amendment protects the right to carry handguns outside the home for self-defense. So Hawaii changed the system. Instead of simply denying carry permits, it restricted where people could actually carry, and one of those restrictions covered private property open to the public unless the owner clearly opted in. The majority saw that as a workaround. Their view was, if someone has a legal carry permit, and almost every ordinary place they go during the day becomes off limits unless they ask for permission first, then the right exists on paper but not in real life. That is why the opinion focused on daily routines. Gas stations, restaurants, grocery stores, the places you visit every day. The court's argument is that the Second Amendment does not just protect a gun sitting at home. After Bruen, it protects carrying for self-defense while moving through ordinary public life. Hawaii's rule, according to the majority, made that too difficult. But the dissent saw the case very differently. Justice Jackson, joined by Sotomayor, argued that this was not really about whether people have a right to carry guns in public. It was about private property. Her point was simple. You do not have a right to enter someone else's property on whatever terms you want. You need the owner's consent, and the states have always had power to define how consent works. Under that view, Hawaii was not banning carry everywhere. It was saying that if you want to bring a gun onto private property, you need the owner to say yes first. That is a property rights argument, and it creates the central conflict in the case. The majority says Hawaii turned the Second Amendment into a permission slip. The dissent says the court turned private property into a gun rights default zone. And that is why this ruling matters beyond Hawaii. Because after Bruen, blue states tried to find ways to regulate public carry. They could no longer just say, you need a special reason to carry a gun, so they started regulating sensitive places, permit rules, and private property defaults. Wolford cuts off one of those strategies. States can still regulate guns in some sensitive places. They can still have licensing systems. Property owners can still say no. But what states cannot do, at least under this ruling, is make every public-facing private business gun-free by default unless the owner affirmatively invites guns in. So the burden shifts. Before, under Hawaii's law, the gun carrier had to look for permission. After this ruling, the business owner may have to look for a sign. And that is not a small change, because many businesses will not want to get involved. Some will not know the rule. Some will avoid posting signs because they do not want political backlash. Some will stay silent because silence is easier. And under the Supreme Court's ruling, silence matters. That is the hidden machinery in this case. The court did not just protect a right in the abstract, it changed the operating system around that right. It changed what happens by default. And once the default changes, everything else changes with it. The burden on the business, the power of the state, the reach of the Second Amendment, the meaning of public access, the relationship between private property and public carry. Hawaii tried to make guns opt in. The Supreme Court said the Constitution makes them much harder to opt out.